But today I've got an introduction to one of the most abused parts of the Constitution, that is, the necessary and proper clause. It's also one of the most complex, which is why we were warned it would be used and abused to expand federal power. Now, the Federalists during the time of ratification, they told us over and over and over that it wouldn't add any new power. It was what was considered a recital. Anti-Federalists warned that even if that was the truth, it was going to be expanded because it was ambiguous. And all along, even at the time of ratification, there were even three different views on the word or the meaning of the word necessary in this legal document from the 18th century. And if there was anything nefarious going on, I think it was with the necessary and proper clause. Let's kick it off with the text of the clause, which is Article 1, Section 8. The Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. Here from our website, this is again Article 1, Section 8, Clause 18. A lot of people tell you that there's 17 powers delegated to the federal government of the Constitution. They're referencing Article 1, Section 8, the first 17 powers, pointing out that the 18th really isn't a delegation of power, but there are other powers delegated throughout the document, somewhere around 30 to 35. But anyways, Article 1, Section 8, Clause 18, necessary and proper, is often called the elastic clause or the sweeping clause because many people believe it gives the federal government power to do just about anything. They started calling it the sweeping clause during the ratification debates. However, necessary and proper doesn't actually delegate any power at all. And here from Rob Nadelson's great paper, The Agency Law Origins of the necessary and proper clause. All these reference links, all these are going to be included in the show notes over at 10thamendmentcenter.com/path to liberty. I'm going to mention a bunch of articles, source documents from the ratification, another episode, etc. Alan Mosley will get that organized and I'll get it published in the next couple of hours. Again, 10thamendmentcenter.com/path to liberty. He points out that this was drafted by lawyers, some of the top ones in the country at the time. The lawyers who drafted the necessary and proper clause took its language directly out of contemporary agency law and usage. So agency law goes all the way back to the common law. It's about, you can think about it in commercial law. It's about principals and agents. So if you own a business and you hire an agent to run your business, there's certain ways to approach that, what they're authorized to do. Hiring people in commercial contracts, etc. Rob goes on. He says the purpose of the clause was to reinforce the role of Congress as the agent of the people, exercising implied incidental powers necessary as a legal term of art for carrying into execution their written instructions, that is the Constitution, subject to prevailing fiduciary norms, which is the proper part of it. Moreover, during the ensuing struggle over whether to adopt the Constitution, this was the meaning, without most of the legal jargon, of course, that the Federalists sold to the ratifying public. And again, this was primarily drafted by some of the top lawyers in the country on the Committee of Detail in the Philadelphia Convention. We've got people like Virginia Governor Edmund Randolph, who at that time I think had taken over Thomas Jefferson's clients. He had Representative George Washington in his business affairs. Washington named him the first Attorney General of the United States. He was a top lawyer. There's John Rutledge of South Carolina, who served as governor of that state. He was also the primary drafter of the Constitution of 1776 for South Carolina, and he was one of the first associate justices of the Supreme Court. There's Oliver Ellsworth of Connecticut, who was later the third Chief Justice of the Supreme Court, and from Pennsylvania, James Wilson, who was a former student of John Dickinson and a future Associate Justice, one of the first that were on the Supreme Court. Now, here's from James Wilson describing the clause during the ratification debates. Again, if we want to understand the legal meaning of anything in the Constitution, we don't necessarily want to just understand what they had to think about it in Philadelphia, because those proceedings were secret. They had no impact on the legal meaning of the document. Any legal document has the same meaning today as it was understood to mean the moment it was given legal force. And the people who gave it legal force were the people of the several states in the ratifying convention. So if you want to understand how they explained it, that's what they approved when they said, we're going to reject the idea of this, or we're going to approve the idea of this. It's based on how it was explained to them. And here's James Wilson in the Pennsylvania ratifying convention. Can the words, the Congress shall have power to make all laws which shall be necessary and proper to carry into execution the foregoing powers, be capable of giving them general legislative power? Of course, that's how it's treated today. They can do anything that they want, and whatever they consider necessary, whatever they consider proper, they can do whatever. In other words, unlimited power in all cases whatsoever, just like what they fought to get away from with the British in the Declaratory Act of 1766. But that was the argument against it. Wilson saying, no, the legal terms mean this. He said, I trust it is meant that they shall have the power of carrying into effect the laws which they shall make under the powers vested in them by this Constitution. He followed up a few days later, again, James Wilson. He said, it gives no more or other powers, nor does it in any degree go beyond the particular enumeration. For when it is said that Congress shall have power to make all laws which shall be necessary and proper, those words are limited and defined by the following, quote, for carrying into execution the foregoing powers. It is saying no more than that the powers we have already particularly given shall be effectually carried into execution. Now, Oliver Ellsworth here writing as a landholder in December of 1787, just a day before that second quote from James Wilson, he suggested that the clause was merely a rule of construction, a recital, as I mentioned before. It's a way to read the document, and as a protection against those who would misrepresent the Constitution. He said, in all these matters and powers given to Congress, they must have authority to enact any laws for executing their powers, or those powers will be evaded by the artful and unjust, and the dishonest trader will defraud the public of its revenue. Of course, we know that revenue collection, which we don't like today, of course, but revenue collection was a big part of why they were saying they needed a new system, or to at least amend the Articles of Confederation. I'm not going to get into Patrick Henry's point that, well, the requisition system under the Articles of Confederation was a great check on centralized power, but that's another conversation. I've discussed it in another episode. Now, here's Alexander Hamilton, who is the worst flip-flopper, and the reason it's important to point him out during the ratification debates. Now, the Federalist Papers weren't super influential out of anywhere outside of New York, but the reason it's important to point out Hamilton is because if the people were sold on something before ratification and Hamilton supported a particular view, the fact that he changed his approach later on, and he was writing in his own diary that he was working to expand powers. We know that he wanted unlimited centralized power. That's what he proposed at the Philadelphia Convention. Other people like Federal Farmer basically pointed out, like, hey, there are certain people who are working to, they're accepting this because it's the best they can get, but they really want to manipulate it into expanding power. So we were warned that there were people like that. We know for sure Alexander Hamilton was one of them. But if he sold the people on what it meant, that's what it was given legal force under that view. The fact that he changed his mind just shows us that people can't be trusted with power. Anyways, Hamilton in Federalist number 33 made explicit what Oliver Ellsworth was suggesting, that the clause gives to Congress no power. And he argued that if Congress is granted a power, it must necessarily be able to draft laws that enable to execute it, that power. He said they are only declaratory. He's talking about both supremacy and necessary and proper. They are only declaratory of a truth which would have resulted by necessary and unavoidable implication from the very act of constituting a federal government and vesting it with certain specified powers. He's basically saying if you're giving it powers, it has the authority just in and of itself to be able to pass laws to carry out those powers. We're just making it very clear with this text. Now, I think Hamilton was being a little underhanded here, but this is truthful. And he said, what is a power but the ability or faculty of doing a thing? What is the ability to do a thing but the power of employing the means necessary to its execution? Necessary. What is a legislative power but a power of making laws? What are the means to execute a legislative power but a laws? What is the power of laying and collecting taxes but a legislative power, or a power of making laws to lay and collect taxes? What are the proper means of executing a power, such a power, but necessary and proper laws? So he's just hammering home that this is just a recital. It is a way to read the document. It's a rule of construction that they have the authority to do stuff to carry their delegated powers into effect. James Madison in Federalist 44 said, without the substance of this power, the whole Constitution would be a dead letter. If they have the power, if they've been delegated the power to establish post offices, but they don't have the ability included in that to be able to hire people to run the post office or to merely lease or buy land in order to establish that post office or pay for the wood or chop down the trees to build the building, et cetera, et cetera. So Madison is saying without the substance of this, without including this, all the delegated powers mean absolutely nothing. It would be impossible. He says in Federalist 44, it basically would be impossible to list all the various ways to carry out a particular power. And that's what we understand in agency commercial law today. If you've authorized someone to run your business, they're authorized to do the necessary and proper things in order to run that business. If you authorize them to run your corner store, you don't have to specifically spell out in the contract that they're authorized to purchase a mop to wash the floor. But if they want to buy a tire store in order to bring more foot traffic, that's a whole different story. They've taken on a power that's greater. So Madison in Federalist 44 also described the power conferred under the necessary and proper clause as, quote, indispensably necessary. And he equates this to those that are requisite, which was defined. Requisite was generally defined in dictionaries at the time as essential. George Nicholas in the Virginia Ratifying Convention repeated this kind of message. He said, the committee will perceive that the Constitution had enumerated all the powers which the general government should have, but did not say how they were to be exercised. It therefore, in this clause, tells us how they shall be exercised. Does it give any new power? I say not. So in other words, the Federalists are saying this is not additional power. This is just reaffirming what the document already tells us. Now, I'm going to get into some complaints about this here in just a little bit because there were plenty, and even from supporters like Edmund Randolph. But this is very similar to the 9th and 10th Amendment. It's not adding new power to the central government. They are rules of construction. It tells us how to read the document. Suppose, he said, this is George Nicholas again, suppose it had been inserted at the end of every power that was delegated, that they should have the power to make laws to carry that into execution. Would this have increased their powers? And he's saying absolutely not. They just put one broad one at the end of the list of the powers specifically delegated to Congress. He said this clause only enables them to carry into execution the powers given to them, but gives them no additional power. And here's James Madison a few days later in that Virginia Ratifying Convention, again reiterating it. It gives them no supplementary power. It only enables them to execute the delegated powers. It is at most but explanatory, for when any power is given, its delegation necessarily involves authority to make laws to execute it. So this is just a repeat. They're saying this over and over. We've got a couple more examples, and then we're going to get into some definitions, some arguments over the meaning of the word necessary, even before the Bank Bill of 1791, but I'll include that as well. He said, were it possible to delineate on paper all those particular cases and circumstances in which legislation by the general legislature would be necessary and leave to the states all the other powers, I imagine no gentleman would object to it. But this is not within the limits of human capacity. And that's what I was saying just a few minutes ago. Madison much better than me on this. He's making a similar argument here in the Virginia Ratifying Convention months later to what he said at the beginning of the year in 1788 in Federalist 44, that you got to have the power to carry the delegated powers into effect. And if you want to list out all the various things, you're going to get stuck at some point because it is impossible to know all the ways, the customary ways to carry things out. But again, this is where you run into trouble because you've got a lot of gray area here with this clause, maybe more than any others. Archibald McLean in North Carolina put it this way. Well, we don't know if it's Archibald. There are two McLeans there. This clause specifies that they shall make laws to carry into execution all the powers vested by this Constitution. Consequently, they can make no laws to execute any other power. So he's saying it's a limit. It's very clear that they can only make laws that are involving the delegated powers, very similar to the Supremacy Clause. This clause gives no new power, but declared that those already given are to be executed by proper laws. They are proper because they are within the bounds of the delegated powers. He said, I hope this will satisfy gentlemen. Now, opponents, the Anti-Federalists, were definitely saying that the clause was ambiguous. And that was going to end up being a problem. John Williams, maybe he was Brutus and Cato, not certain, but he said it is perhaps utterly impossible fully to define this power. If the objects of this power cannot be comprehended, how is it possible to understand the extent of that power? He's acknowledging what James Madison was saying in Federalist 44. Now, he's in New York. The Federalist Papers, which Madison wrote, were for a New York audience. So this was very influential in New York. And the Federalists are telling people, like, look, it's impossible to think of all the ways that you might exercise or pass laws to exercise one of the delegated powers. So you have to have this. Without it, it's bad. Now, on the Anti-Federalist side, they're saying, well, no, hold on a second. Because it's impossible to think of all this stuff that might be used to pass laws, to exercise delegated powers, that means it's basically unlimited. If we can't think of all the different ways it can be used, then certainly people with power are going to find ways to use it. He said, a case cannot be conceived which is not included in this power. And because of this, the following day, he said, whatever they judge necessary for the proper administration of the powers lodged in them, they may execute without any check or impediment. Because it's so broad, all you have to do is point to a delegated power, and there's all kinds of ways that you can, if you're reading it in a broad way, and we find out that that's what they do pretty quickly, if you read it broadly, certainly there's no way to limit anything. It is an unlimited power. And John Williams was very representative of what, his take here was very representative of what so many other Anti-Federalists, whether it was Brutus or Cato or Federal Farmer or Patrick Henry, over and over basically said this same thing. It's ambiguous. It's not clear. And so therefore, well, what's going to happen when government has unclear powers? They're going to do all kinds of stuff. Now, during these ratification debates, we end up with three views of the word necessary, because that's really, really important here. What does it mean to say that something is necessary? Version 1 is necessary means indispensable. So it's absolutely necessary. Now, James Madison described this some years later, again, in his speech against the bank bill in February of 1791. And he said, whatever meaning this clause may have, none can be admitted that would give an unlimited discretion to Congress. So if they can determine what's necessary, then they have unlimited discretion. Now, if there's some actual meaning to the word necessary, then it's a little different. And he said its meaning must, according to the natural and obvious force of the terms and the context, be limited to means necessary to the end and incident to the nature of the specified power. So necessary, he's using this in indispensably necessary and as a lesser power. So the example I gave of running a corner store, it's incidental power. The dude who's running your store for you, it's incidental. You don't have to spell it out, that he can buy a mop or hire people or maybe add a security system. Now, you might want to restrict the amount that he can spend on certain things, but you got to spell that out. That's an incidental power. A power that's greater than the original power would be to buy a couple more stores in order to get more foot traffic. That might be It might be helpful, it might be conducive to the business, but it is not an incidental power, incidental to the nature of the power. Thomas Jefferson also took this type of necessary means, well, indispensable means necessary. It means what the word tells us it means. He said the Constitution allows only the means which are necessary, and not those which are merely convenient for effecting the enumerated powers. That is to say, to those means without which the grant of power would be nugatory. So in other words, necessary to carrying out the power means if you can't do it, you can't exercise the power. I use the post office and post roads. If they can establish a post office, but they're not able to hire people to run it, then you can't actually establish a post office. You can just put it on paper, but they're not able to do it. So that's a good example, I think, maybe I'm not good at analogies. Now, in response to Thomas Jefferson and James Madison, Alexander Hamilton in 1791 argued, now we had the same kind of debate. The Anti-Federalists warned us that they were going to, you had some Anti-Federalists during ratification telling us, oh yeah, whatever. This is not limiting. This is not a recital. This is not a rule of construction. This is giving them unlimited power. They can do whatever they choose is convenient to their own power. Others were saying, yeah, okay, even if you can tell us that this is based on the legal doctrine of principles and incidents, the agency law, or what Madison said specifically, this is about incidental power. Even if you can tell us that, then, well, someone with power is going to read it broadly because we can't trust anyone with power. Even John Dickinson, who was one of the Federalists, back during his heyday in the American Revolution, he warned that all artful rulers who strive to extend their power beyond its just limits will always strive to give it as much semblance of legality as possible. We know that people with power will always try to claim that everything that they do is legal, that everything they do is necessary and proper. So Hamilton in 1791 was basically making some of the Anti-Federalist arguments. He was basically saying that necessary really often meant little more than convenient to the exercise of their other powers, and so therefore almost unlimited. And in 1819, surprise, surprise, Chief Justice John Marshall adopted the view that necessary doesn't mean necessary, it means convenient. And he adopted, in some places, word for word, the Hamiltonian argument in 1791. And also, years earlier, in a case, U.S. versus Fisher, Marshall had already given almost complete discretion to Congress. Remember what James Madison said. He said, no version of this clause can be admitted if it gives unlimited discretion to Congress. That was in 1791. By 1803, Marshall is saying, well, they have unlimited discretion to determine what is necessary to carry out their own powers. That's exactly what John Williams warned. Based on how it was written, he's like, this is ambiguous. And so therefore, when they read it, they're going to tell you that everything is necessary and everything is proper because this is what people with power do. And this should be so obvious today. But anyways, I covered this changing of the meaning of the word necessary into the word convenient in an episode almost 2 years ago. Necessary is supposed to be necessary. I'm sure I covered it other times as well. That will also be linked to in the show notes. Now, Nadelson points out, now he did some research for this article, some pretty deep, well, this is dozens of pages, but he went through all the leading dictionaries of the time, not just one or two, not just Samuel Johnson's, and of course, not Webster's dictionary from 1828, which so many people seem to use today. I don't understand why, because no one in 1787, no one in 1791 was reading an 1828 dictionary, and that dictionary could have different meanings. So it's dumb to start with 1828. Don't do it. If you read the dictionaries from the time, 1760s through 1790-ish, up through ratification of the Bill of Rights, 91, then you can understand how the people understood the words or defined the words. And he says the leading dictionary of the time lists multiple entries for the word necessary, but not a single one of these entries comes close to expedient, convenient, or useful. They were all basically indispensably necessary. The word necessary as we understand it. If it's necessary to do this, it means it has to be done. So that's view 2 is necessary means convenient, even though no one understood the word necessary during ratification to mean convenient other than Alexander Hamilton behind the scenes and then pushing for it, and then George Washington signed it into law. But here's somewhere in the middle, we get Edmund Randolph, who was the AG. He was one of the drafters of the clause. And here he is on his opinion on the bank bill in February of 1791. He said, to be necessary is to be incidental, or in other words, may be denominated the natural means of executing a power. The phrase, and proper, if it has my meaning, does not enlarge the powers of Congress, but rather restricts them. For no power is to be assumed under the general clause, but such as is not only necessary and proper, or perhaps expedient also, but as the friends to the bill ought not to claim, blah, blah, blah. You can read it in full. But he's basically taking kind of a middle of the road between Hamilton and Jefferson and Madison. It sounds similar because he's saying necessary means incidental, but it also means something more. And he says this is back in the Virginia ratifying convention where he points out that he's actually disagreeing with the Federalists and the Anti-Federalists, the people who say that it means indispensably necessary, and then on the Federalist side, and then the Anti-Federalists who are saying, well, this is going to give them unlimited power. He said they're all wrong. It gives no supplementary power, but only enables them to make laws to execute the delegated powers, or in other words, it only involves the powers incidental to those expressly delegated. By incidental powers, they mean those which are necessary for the principal thing. Again, it sounds very similar, but this legalese stuff, and this is where we get screwed over, is it make the more complex. And I just did an episode on Federal Farmer's papers number 4 and 5 just in the last couple of weeks, and Federal Farmer was very concerned about undefined power. This was one of the leading arguments on the Anti-Federalist side. If it's not super clear, we know that tyrants will do what tyrants do. They get into power and they use undefined power or not clearly defined power to expand their power. So this sounds very similar. But he says that the incident is inseparable from the principle is a maxim in the construction of laws. So he's referring to the agency laws, so the common law, what we're used to. That necessary means, it means necessary. It means it's inseparable. You can't do the principal power without the incidental power. But, and here's where he kind of goes off the rails here, but maybe he was right. I don't know. A constitution differs from a law. It's not the same. For a law embraces one thing, but a constitution embraces a number of things and is to have a more liberal construction. And his version was basically that it was expedient. It's reasonably necessary and not absolutely necessary. So that's a middle of the road there from Randolph. And here he is pointing out that in the Virginia ratifying convention that everybody else is getting it wrong. Now, I haven't found too many people that agreed with Randolph, and I think we've made a mistake by basically running with his view in some places over the years. I said when I opened my observations that I thought the friends of the Constitution were mistaken when they suppose the powers granted by the necessary and proper clause to be merely incidental only. And its enemies were equally mistaken when they put such an extravagant construction upon it, unlimited power. So Randolph is basically saying they're all wrong. And so we've actually run with the Randolph view, and I believe, as I've learned more on this, that we're wrong. And hopefully we're going to make some edits on this page, maybe not this week, but sometime soon. But this is how we've described a so-called incidental power. It's basically based on the Randolph approach. It had to meet certain requirements. I need some water here. 1, it was subsidiary to or less important than a listed or principal power. Incidental powers had to be less worthy than the principal. And then it had to be a customary way of exercising a power. It would be reasonably necessary, and that is the Edmund Randolph view. Now, Thomas Jefferson basically told us that if you didn't look at necessary as just what it's supposed to mean, the word necessary, and instead you looked at it as convenient, you're going to end up with all kinds of problems. He said, if such a latitude of construction be allowed to this phrase as to give any non-enumerated power, it will go to everyone. For there is not one which ingenuity may not torture into a convenience in some instance or another, to some one of so long a list of enumerated powers. It would swallow up all the delegated powers and reduce the whole to one power. Because if you only need the necessary and proper clause, if they can do whatever they consider is convenient, they basically are unlimited in their power. Now, we also want to look at proper. There wasn't a lot of debate over the meaning of the word and or the meaning of the word proper. But here's how Rob Nadelson puts it in his paper, Agency Law, Origins of the Necessary and Proper Clause. Again, that'll be linked to in the show notes. He said, in an important investigation of the subject, Gary Lawson and Patricia B. Granger relied on the founder's use of the earliest sense of the word proper, various dictionaries, speeches, articles, and the like, to argue that a proper law was one that respected the legal terrain belonging to the other branches of government, the states, and the people. So as long as they respected the separation of powers, the delegated and reserved powers, then it could be proper. That conclusion may be correct as far as it goes, but substantively, it mostly reaffirms the rather obvious point that Congress may not pass an unconstitutional law. And if we think about what Edmund Randolph said, one of the guys who drafted this, he's basically saying if it has any meaning at all, it adds a restriction. It's basically saying you can't exercise anything that is not enumerated. And hear from Randy Barnett in Original Meaning of the Necessary and Proper Clause, and this was in, I think, around 2003. Barnett, who I think is very good on some things, he does lump Edmund Randolph in with the same view or definition of necessary as with Thomas Jefferson and James Madison. And I think it's very clear that Edmund Randolph had a different approach. And this is where I would disagree with Randy, but a lot of the other research in here is very good. In sum, for a law to be proper, it must not only be necessary, it must also be within the jurisdiction of Congress. This propriety of jurisdiction is determined in at least three ways. See how complex this is? 1, according to the principles of separation of powers. 2, according to the principles of federalism, delegated and reserve powers. And 3, according to the background rights retained by the people. This is Ninth Amendment stuff right here, of course, from Barnett. This it looks like it's, November of 2003. So proper, really, there wasn't a lot of debate over it. The concern was, how would they define what is necessary? And if you got 3 versions of it, 2 of which give some latitude to Congress, we shouldn't be surprised that through implication, they've expanded their power over and over and over. And even if you look at some of the Commerce Clause cases that came out of the New Deal that expanded federal power to where it is today, sometimes the federal courts have actually gotten relatively close to how the founders understood the meaning of commerce, interstate commerce, but they've combined that with a very expansive view of the necessary and proper clause because John Marshall is a god to all lawyers, and he can do no wrong, and Hamilton is wonderful, and all this stuff. And so therefore, even when they get something right, they still expand power because necessary and proper is attached to anything. And that's just what John Williams and so many others warned us about, or Patrick Henry in the Virginia Ratifying Convention. He warned that implication is dangerous because it is unbounded. If it's not clearly spelled out, they will end up with unlimited power. He said, if it be admitted at all and no limits be prescribed, it admits of the utmost extension. He warned exactly what would happen. And I mentioned Federal Farmer. Of course, he argued in his 4th paper, I believe, that necessary and proper was very poorly defined. And he pointed out that men who govern will, in doubtful cases, construe laws and constitutions most favorably for increasing their own powers. And even Edmund Randolph, the guy that I think was probably most influential on some of the leading scholars of today, if you see the conclusion that both Nadelson and Barnett, and by extension, because we've learned so much from these guys on various issues, not on everything, but we've learned quite a bit on some of this originalist research, we've kind of run with the Randolph view, and I'm pretty confident that that's incorrect, and we've got to change this to how it was sold to the people. And I don't see too many other people taking the Edmund Randolph view. I'm going to do more research, though. But Randolph himself, in the Virginia Ratifying Convention, specifically warned that the clause was ambiguous and it was going to be abused. He said, my objection is that the clause is ambiguous, and that ambiguity may injure the states. My fear is that it will, by gradual accessions, gather to a dangerous length. This is my apprehension, and I disdain to disown it. Now, he was arguing for ratification at this point, even though he was against it originally. And one of the reasons that he didn't like it is he didn't like one of the clauses he was so influential in drafting in the Committee of Detail in Pennsylvania or in Philadelphia. And he's saying, look, it's ambiguous. He's actually agreeing with the Anti-Federalists. And that's exactly what happened. And here's how Patrick Henry put it a few days later in the Virginia Ratifying Convention. This is June 16th. He said, by this, they have a right to pass any law that may facilitate the execution of their acts. It might be convenient to it. That's basically what Hamilton ran with. So Patrick Henry is saying this. It may facilitate. It might be convenient, in essence. And they're going to be able to do this. And the Federalists said, no, this is incorrect. Other than Randolph, they basically said, this is incorrect. And then they ratified based on that debate. And then a few years later, Hamilton decides to go back with what it was warning against and what was rejected rather than what was approved. Patrick Henry said, will not this clause give them a right to keep a powerful army continually on foot if they think it necessary to aid the execution of their laws? Is there any act, however atrocious, which they cannot do by virtue of this clause? I think that warning really hit the nail on the head. I don't have a lot of time to go through the live chat today, but I really appreciate you all being here. There's Litecoin Liberty over on X, Howard Clegg, Ruben, Haji, John Rame, Sonny Bono, Ben Watson, Dixie Strong, Melody, and many others. Tyler B., King Nobody. I appreciate you all being here. If you want to help us get this kind of important historical information out to more and more people, absolutely nothing helps us do this work more than the financial faith and support of our members. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. If you got a couple of bucks of that dirty government fiat, of course, we'll take LTC or any other non-government run so-called money. But if you got a couple of bucks of that dirty government fiat, please consider throwing it our way. We also have annual 5-year and lifetime options. 10thamendmentcenter.com/members. Howard Clegg, you're absolutely right. Henry nailed it. That's what he was warning about. And again, I think where the Anti-Federalists really understood things is they had kind of a long-term. Now, they didn't get everything right, certainly. And I think some of the debate over the Bill of Rights, sometimes the Federalists were actually correct on these things. And maybe I need to do some episodes or articles covering where I think one side or the other made a stronger case. But certainly when it comes to understanding the nature of humanity, human beings, and the nature of power, the Anti-Federalists were far better on this. They didn't want to trust that you would just create a system that the best people would rise to the top. Patrick Henry specifically discussed this. He's like, yeah, okay, if you've got good senators, good representatives, and a good executive, of course everything's going to be cool because they're going to follow the rules that are given to them. But can this be expected from human nature? And I think if you approach these things, and even today, the lesson for today, if you think government should do something in order to make you feel safe or protect, whatever it is you're freaking out about, if you think government should do something additional today, because you think it's a good reason, you have to imagine the worst person on the face of the earth, your greatest enemy, having that power sometime in the future, because eventually that person will have that power and they're not going to use it in ways that you like. Anyways, I really appreciate you being here. Again, thank you so much for watching the show. I hope you enjoyed it. I hope you learned something, and I hope to see you next time here on the path to liberty.